A last-minute change before a long-awaited murder trial in St. Johns County. The teenager accused of murdering 13-year-old Tristyn Bailey changes his plea to guilty.
Aiden Fucci still faces life behind bars. Now, to break all of this down for us is On Your Side's Renata DiGregorio. So, Renata, his guilty plea, quite the surprise this morning.
It was a big surprise. Potential jurors were waiting in another room in the courthouse, getting ready for the jury to be picked. The jury selection and the trial were expected to last multiple weeks. Now, what this guilty plea means is that Fucci is pleading guilty to first-degree murder, stabbing 13-year-old Tristyn Bailey 114 times when he was 14 years old. The courtroom was planning to show nearly 50 photos of Bailey, and we're hearing now from some people in the community saying that they're glad the Bailey family will not have to go through that and the trial. So moving forward, the defense says they need 10 days to compile a witness list and discovery before the sentencing. The sentencing hearing is expected to last 2 days, and they'll be back in court February 23rd to decide on a date for that. Towards the end of the relatively short court appearance this morning, Fucci's attorney said he wanted to make this statement.
Mr. Fucci, is it your desire to enter a plea of guilty to one count of first-degree murder?
Yes, sir. And I'm sorry for the Bailey family and my family.
Fucci still faces possible life behind bars with the possible review of his sentence after 25 years. Now, very few people were allowed in the courtroom, but one of those people was our executive producer, Ann Schindler. Now, Ann, tell us about the mood in the courtroom. A lot of people couldn't be in there, so you have the insight.
Yeah, it was actually a really empty courtroom because we'd expected it to be packed out with jurors. Shortly before the defendant entered the courtroom, though, the family entered and kind of took the first 2 rows, so we knew something was developing. Aiden Fucci was the first time we'd seen him not wearing a jumpsuit, a jail jumpsuit, so he was in a suit and tie today. But a reminder of just how young he was when the judge was doing his interrogatories and asking him, if he was in fact pleading guilty. He asked him how far he'd gotten in school, and he said 8th grade. So again, just kind of a reminder of just the unusual nature of this case all around.
Yeah, definitely when they said 8th grade, it kind of hits you like, oh yeah, they are still in middle school. And we did learn a little bit about Fucci as well that we didn't know before. Can you explain about that?
Yeah, that's right. So one of the things that the judge has to do in assessing and kind of finalizing that plea is to ask if they're under the influence of any medication. He said he was, and he listed off 3 drugs that are antidepressants and antipsychotics. So, whether or not his mental health will be a mitigating factor, something that's introduced to the judge at sentencing for a possibly more lenient sentence, something that could come up. We just don't know.
And as far as the Bailey family, we've gotten word that they are expected to release a statement a little later on today. We do not know anything. They're not releasing anything right now, though. So be sure to tune in, though, because we'll be back here at First Coast News at 5, and we'll have that statement and, of course, more continuing coverage on this. But for now, we're going to send things back to you guys in the studio.
Thanks for that, Renata DiGregorio and Ann Schindler there in St. Johns County. Now, with this news coming in the past couple of hours, it leaves a lot of questions about the next steps.
So Jeannie Blaylock is speaking with our legal analyst about all of this to talk more about those next steps. Jeannie.
Yeah, let's do that. What does happen next? Let's talk now to our legal analyst, Shannon Schott. She is an expert on juvenile law, a defense attorney. We appreciate your joining us. You just got off the phone with a private attorney for Tristyn Bailey's family. What did he tell you?
They will be issuing a statement around 4 o'clock this afternoon, and they're ready to make a statement about the shocking development in this case.
A lot of people using the word surprise, shock, dramatic. Nobody expected it. You were surprised greatly as well by this change of events today. And so what happened? Why the last minute?
I just got chills. It is very shocking and surprising, and it's interesting that they chose to do it on the morning of jury selection, but that's really the last opportunity that a defendant has to change his plea and give the family some solace and give the state an opportunity to not have to go through the process of proving the case beyond a reasonable doubt. And perhaps he and his team thought from a strategic standpoint he would win some favor with the court when it comes time for sentencing.
So you'd win favor by the court, presumably because you leave the family without having to hear so much of a trial day after day after day. But doesn't the judge see through that?
Certainly there may be a question as to whether or not that remorse is sincere, and that will be a question for the judge alone to decide. But certainly there is an argument to be made that he spared the family from the medical examiner's testimony, which was going to be extremely difficult for everyone involved.
You were telling me when I talked to you earlier today that remorse is an enormous factor. Mm-hmm. The judge has to believe that he is sincerely sorry. Now, we heard him give a statement. You all just heard that now. It was very very short today. Do you think that helped him win some points with the judge, or would you have advised him differently?
So under Florida law, remorse cannot be considered in sentencing unless the defendant raises it as an issue. I think that when you set the tone for your sentencing hearing by saying, I'm sorry, that just gives a little bit of a preview as to what's coming. And there will be an emphasis on his remorse made by the defense. And what we've now heard is going to be a 2-day sentencing hearing.
Now, how would you evaluate that sentence? It was very, very short, as I say. Do you think that made the first impression that was what you would want it to make for the judge?
He's a teenage boy with limited developmental skills and limited communication skills. There will be work that has to be done to really communicate his remorse to the judge. I don't think that's the be-all, end-all when it comes to what the court's going to consider for remorse. But based on that sentence, there's certainly work that needs to be done.
How would you coach him to become more sincere sounding, perhaps, if you were his defense attorney?
Well, what the job of the defense attorney is basically to present that mitigation or good information. And there will be an element of drafting a more detailed statement, potentially if they're going to raise the issue of remorse and bring that in as mitigation or good information. And there just needs to be work done on the way that it's communicated, what is said, other than just, I'm sorry. I don't know that that's sufficient for the court to consider. There needs to be a lot more that goes into that statement. And there just needs to be thought. So when we work with our juvenile offenders, we always encourage them to really take time to write their letters of apology and be very sincere when they write it.
So let's talk more about why this was a last-minute thing. We've been seeing through public documents in our newscast the last couple of days about statements that he supposedly made in jail to other inmates. Basically, I don't know if bragging is the correct word, but saying that he was the one with a knife to somebody's face and trying to keep them from either assaulting him or I don't know, overcoming him in some way in prison. Do you think that had an effect in this last-minute change?
Certainly, there are a number of factors that could have affected whether or not he was going to plead guilty or proceed to trial. But it's definitely important to note that some of the inmates that he was incarcerated with are listed on the witness list. It is possible that the state was going to bring those witnesses to testify about statements that were made by Mr. Fucci that only the killer would have known. So in light of that, that evidence could have been the last straw for his attorneys to say, look, you are going to be convicted, and if you plea now and save the family the trial, maybe we can do something with that information. But it sounds like in the last few days there's been a lot of developments with the witness list and who will be testifying and the testimony that's coming out.
So let's clear up the possible sentences and what kind of punishment he could get. We've been seeing lots of talk on social media. You and I chatted about this. People saying, well, he's not going to get life in prison. I mean, nobody knows that. It's up to a judge. It's not a jury at this point for the sentencing hearing. But at 40 years, there would be some kind of possible change, but there's a review before that if he gets life in prison at 25 years. What happens in a review? What does that mean? Could he walk free?
Yes, so Florida law has a lot of rules. In the last 10 years, we have codified or made laws that talk about juvenile sentencing. And this is where my expertise really comes in, because when you have a juvenile offender charged as an adult, there's two things happening. You have a juvenile case and juvenile rules that apply to him right now. So they actually ordered a juvenile predisposition report. And then you have the possibility of an adult sanction as well. So he could either be sentenced as a juvenile and he would be incarcerated until he's 21 and the court loses jurisdiction, or he would be sentenced as an adult to 40 years to life. And if he's sentenced to 40 years or more, or life, he would be reviewed at 25 years. And if the court determines based on a bunch of factors that he should be released back into society, he would be released and then put on a minimum 5-year probation.
So at minimum, he will be in prison 25 years. After that, we don't know. All right.
Correct.
Shannon, we appreciate your help. We'll
Thank you.
be talking to you live tonight at 5:30 on First Coast News, and we appreciate your expertise. Back to you guys over there.